What's up, viewers, subscribers, and agents alike? This your boy Night Luciferian Prince coming to you early this morning in regards to a video I have on specific negative averment. Now, in this video, it will elaborate a lot more on the concept of what specific negative averment is and how it applies to the civics and or the contract ideology in regards to pretty much everything in commercial activity. But before I proceed, I will say this. This does not constitute legal advice, but the sole information is for educational purposes in regards to the legal side of the informative process. That's a different twist in the beginning, people, and I don't want to get it confused because I know that I know who watches my channel. I know that there are interests who watch the channel in regards to it, and it doesn't really matter. I mean, it's quite understandable. It's quite understandable, actually. And I also want to get into this because I want people to know that whenever you engage in a contract, you're basically transferring your commercial energy onto a piece of paper. So, Erie Railroad versus Tompkins in 1938 declared that where there's no contract, there's no case in regards to the process and procedure. So I know that a lot of people are facing foreclosures. They have instances where they particularly don't really know what the viable instance is in regards to their redemption in regards to a contract. So specific negative averment, to be honest with you, is a very powerful remedy. It's a very powerful presentment that a secured party creditor can use, and a person who has basically moved far in the process of these steps really knows how to execute this legal maneuver. Now, I'm gonna read this again because I came from an case law, not my own opinion or my own conjecture, in which I actually have studied quite extensively. But this comes from AG Adjustments Ltd. versus Juarez 369 SW 3D 768 Missouri Appellate Court 2012. And this case basically just legally simplifies it. But I'm going to basically break it down on two levels: legal and what I like to also say legal in layman's terms. It says it should be sufficient to aver the ultimate fact of the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of a corporation or of an organized association of persons that is made a party. When a person desires to raise an issue as to the legal existence of any party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, the person shall do so by a specific negative averment, which shall include such supporting particulars as to the particularity within the pleader's knowledge. When a party so raises such issue, the burden of proof then shall be placed upon the opposite party. In other words, people, in the legal sense, what you have to do is legally draw up the instrument in regards to the affidavit format. And the affidavit format is the documentation which basically alleges the capacity in which you are and which you are not. Now, the truth is, in regards to the legal process, it's the affidavit format, but in the layman's terms, and as simplistically as I can put it, it just proves that you're not the entity that is being proceeded against legally. In other words, you're not the corporation. Most people don't know how to actually draw up specific negative averment affidavits, and I myself do. I myself also provide the assistance in regards to what it is, and I know that today, now more than ever, legal entities are proceeding against people, and I know that the capacity legally is for most lawyers who also watch my channel, those who have interest in the financial arena, are trying to keep people bound in with contracts. Now, this is a very effective measure because they lose jurisdiction over the res, so to speak, over the person, not the natural person, because you nullify the jurisdiction that's over that particular entity that they're proceeding against. So remember, as I said in my last video in regards to trust, it's not you. It's just that your identity has been transferred. So as it says in the last part, when a party so reason to issue, the burden of proof thereon shall be placed on the opposite party. So in other words, the burden of the contract in regards to the subject matter jurisdiction is placed on the opposing side. So with your capacity and with your knowledge in regards to specific negative averment, what you're doing is basically ousting the jurisdiction for them to basically proceed against you legally. If you wish to further enhance your knowledge on this, please email me in regards to this. We can definitely speak about this, and I can show you hardcore proof and facts that I myself have done this. You know, most people on these YouTube channels have very little to no proof, but that's just what I know. In my personal life, I never advise something for somebody that I have not done myself, or I will not do for myself later on. So if you do need help in regards to your processes, in regards to understanding the capabilities that go behind the idea, so to speak, of jurisdiction in regards to contracts and commercial law, please email me. But specific negative averment, people, in the layman's terms, is just simply saying you're not what the legal system declares you to be, because you have separated the identity from the fiction and the natural person. It's just that simple, you know? And I also want to mention on this video, people who schedule times to talk to me, consultations, whatever the case may be, I will say this: please keep up with the schedule. I know that today, now more than ever, people have things going on in their personal life and so on, and so do I. So if you wish to speak to me, please give me an approximate time that you can keep, and we can go from there. Other than that, that's it, people. Peace. And agents, you know, it is what it is. Take care. Love y'all.